Hi everyone, my name is Mahshid. I'm one of the lawyers at Connect Family Law, and today I wanted to talk to you about a question I get asked often, which is, do I have to share in my RRSPs and my pension with my spouse, even if I'm the only one that contributed to it? The quick answer to that is yes, you generally do. So any assets that are accumulated during the relationship, regardless of whose name it's in or who contributed to it, is usually equally divided between the parties. Now, some people may want to try to argue that this is significantly unfair and that the court should order some type of reapportionment between the parties. And what I usually tell my clients is that although you can make those arguments and they are available to you, it is a very high threshold to meet. And simply saying that you only contributed to that asset usually isn't sufficient to meet that threshold. And a lot of clients who hear this, they have some resentment or bitterness, understandably so, because they feel that in dividing the RRSPs and the pension, they're contributing to the spouse way after separation. And one thing that I tell clients, which may not be the most comforting, but it's something that I like to acknowledge, is that the law accounts for the fact that while one party is contributing to an asset, another party is contributing to other assets or the relationship in other ways. And so when you take a step back and look at it as a whole, you realize that it's an effort by both parties to accumulate those assets. And at the end of the day, I always like to remind people that if you are dividing your RRSPs or your pension, make sure you always get some type of tax advice, and that's because there are some implications there that you should be aware of before you move forward with the process. So if you have any questions or comments, just comment below, and thanks for listening.